That's a fascinating question, and it does lead to some interesting litigation. Most of the time, the litigation is not all that heated. So the Bankruptcy Code has a provision that permits a debtor to avoid a judgment lien. Now, this is a somewhat unusual usage of the word avoid. It means to render null and void. So you can avoid a judgment lien against some asset of yours to the extent that it impairs your exemption. Now, what does that mean? Well, I'm thinking right now in terms of a personal bankruptcy. The concept of exemption does not really come up if we're dealing with a business bankruptcy. With a personal bankruptcy, and perhaps it will be helpful if we focus our attention on Chapter 7. The big picture goal is, of course, to get rid of the in personam liability. And because the relief is really quite sweeping, you just get rid of debts without paying a dime, there have to be some limitations, of course. And one limitation is on what you get to keep. You get to keep some stuff, but there's at least the potential to lose possessions in a Chapter 7 bankruptcy. So one of the things we include in a Chapter 7 petition is a complete listing of everything you own or have an interest in. And all of your assets get divided into two categories, exempt and non-exempt. You get to keep the exempt stuff, but the non-exempt stuff is fair game for the Chapter 7 trustee appointed to the case to seize and liquidate and have money to pay your creditors. We determine whether something's exempt or non-exempt by appealing to one of two exemption tables. One table is for homeowners with equity, the other's for everybody else. Oh, by the way, if you're in another state, what I'm saying might not apply. I'm specifically speaking of California. So, what does that mean? It means anything that is exempt in a Chapter 7, the Chapter 7 trustee can't touch. It's yours to keep. It does play a role in other chapters, but for purposes of lien avoidance, it's helpful to have that Chapter 7 image in mind. Now, suppose someone has recorded a judgment lien against that asset. Most commonly, this comes up if it's real property, although there is certainly the potential for somebody to have a judgment lien against personal property. Not so common, though, because personal property doesn't have the same kind of value. In any event, let's say there is a judgment lien against your home. While you're in the bankruptcy case, and by the way, you can do this regardless of chapter, but we are sort of focusing in on Chapter 7. You can remove that lien, avoid the lien to the extent that it impairs the exemption. What does this mean, impairs the exemption? The Bankruptcy Code has a little arithmetic formula that helps us to determine whether an exemption is impaired or not. What we do is we take the sum of all the liens, including the lien you're seeking to get rid of, but any other liens that encumber the property, including a mortgage, because even though that's a consensual lien that you're not necessarily getting rid of, it's still a lien against the property. So we add up the value of all those liens. Then we toss in the value of the exemption that you could have taken on the property if there had been no liens. We finally get a number. Then we compare that number to the market value, the current market value of the property. To the extent that that sum exceeds the market value of the property, to that extent, you can remove the lien, because to that extent, the exemption is impaired by the lien. Now, you can see there can be a problem if the value of the property is shot up, and now the value of the property is larger than the sum of the liens plus the exemption. So the arithmetic has to work out, and this is one of those things that's relatively mechanical. Either the arithmetic works out or it doesn't. What do we need in a situation like that? Well, clearly we're going to need to have some way to establish what the value of the property is. So we need an appraisal. Now, an appraisal all by itself is hearsay. So we have to have an appraisal from an appraiser who is willing to sign a declaration under penalty of perjury saying that this is the value of the appraisal of the property. This appraisal is accurate. We also need certified copies of the various liens because we're going to add up their balances and we need to know exactly what the balances are. And the valuation is done for lien avoidance in this context on the day we file the petition. The bankruptcy code's clear on that. So to the extent that it impairs the exemption, to that extent we can remove the judgment lien. Now, sometimes if it's really close and the judgment lien is large enough, you might end up with a battle of the appraisers. So the creditor who doesn't want the judgment lien avoided may come up with an appraisal that's much higher than the appraisal that you say that is an accurate measurement of the value of the property. And so then the judge has to determine which appraisal to believe. But most of the time, judgment lien avoidance actions are not opposed. Occasionally they are, but not very often. So that's what we mean by avoiding a judgment lien, getting rid of a judgment lien in bankruptcy. And although I did focus on Chapter 7, it was more to have the mindset of what it means to have an exemption. You can avoid judgment liens in any chapter, but remember this is within the context of a personal bankruptcy because businesses don't have exemptions, only individuals do.